Hello, I'm Dalton Delan. I'm a columnist for the Berkshire Eagle, and this is Eagle Reels, where we take you beyond the news. Our very special guest today, Joseph Nunn at the Brennan Center for Justice at NYU. Welcome, Joseph.
Thank you so much, Dalton, for having me.
Thank you. We're going to discuss the National Guard deployment today, historically and in the present day. And let's go back and get a little history because I don't think it's well known for our readers and our viewers. The Guard traces its origins actually in Massachusetts to 1636, the first colony-wide militia under British rule.
Yeah, that's right. The National Guard today is the sort of modern incarnation of the old state militias that are discussed in the Constitution, but actually predate the Constitution. The Guard forms, you might say, the sort of principal reserve of the active duty armed forces. So National Guardsmen are soldiers and airmen, and they are trained, equipped in the same way as their active duty counterparts and wear the same uniforms. But they also have, civilian jobs and civilian lives that they, spend most of their time living.
Yes, yes. I actually we have a cousin serving right now in the Air Guard. Now, the National Guard, that term was first used in New York in 1824 and then nationally in 1903. That's still a good long history.
That's right. So the National Guard as we know it really originates in 1903 when Congress enacted the Dick Act. This was the culmination of, well, what you might say is this culmination of Congress's frustration and often the president's frustration with the militias that were sort of inconsistently trained and equipped from state to state and did not have a sort of stellar track record up to that point. So with the Dick Act, Congress was trying to sort of regularize training and equipment of the National Guard and turn it into a sort of uniform force that would be could be sort of relied on in a crisis. That process didn't stop with the Dick Act. A lot of the law governing the way the National Guard works today was actually dates to 1933. So it was a sort of multi-decade process of figuring out how to modernize these militias for the needs of the kind of industrialized modern United States.
Joseph, that congressional Article 1, Section 8 that gives it the power to, quote, raise and support armies, unquote. We're going to get to in a minute, but Congress did this. We're going to get to also quickly the state role, that dual role. But so how did the president factor in? Was it just as commander in chief, or how was that thought of? We're going to get to where today that's a dominant characteristic, but is that a surprise or was that in there from the beginning?
So as a constitutional matter, the president has very little independent authority in this area. So the militia clauses, Article 1, Section 8, clauses 15 and 16, give Congress very nearly plenary authority over the militias, what they look like and how they can be used domestically. The calling forth clause empowers, Congress to provide for calling forth the militia to repel invasions, suppress insurrections, execute the laws of the Union. The sort of other militia clause empowers Congress to sort of regulate the militia, how they're trained, how they're equipped, how they're organized, reserving to the states only the power to appoint officers and the power to train the militia according to the discipline prescribed by Congress. So this is an area where Congress is firmly in charge. The president has precisely the authority over the National Guard that Congress says he has, and no more than that. in terms of, the commander-in-chief clause is a sort of perilous thing to interpret, because it's doesn't say a lot, but it's been read to mean a lot. And it's more than an empty title. The president certainly, directs military operations. He is in charge of the armed forces, but Congress still controls, what he can do with the armed forces, when, under what circumstances he can do it, and all of the sort of everything about regulating, governing the armed forces, including the militia, that is the National Guard, that is Congress's domain to shape as however they see fit.
What so in brief, this odd duality of the state and the federal government control. Can you elucidate that for us? It seems hard to understand. And how does, do you need the state to approve? How does that work? Obviously, again, this is going to play out in the present day.
Yeah, so the what you're getting at there is that the National Guard is this unique creature of both state and federal law. It's organized at the state and territorial level. So there are 54 National Guards, one for each state, and then National Guards also for Puerto Rico, Guam, the U.S. Virgin Islands, and the District of Columbia. Um, and with the exception of the D.C. National Guard, which is always under the president's command and control, each National Guard is by default under the command of its state or territorial governor. So there is this sort of element, organized at the state and territorial level, by default under state and territorial command and control. But at the same time, the Guard is largely governed by federal law, and it receives most of its funding from the federal government. It's also the case that under circumstances defined by Congress, the president can call into federal service or federalize the National Guard, which, and when and under what circumstances the president can do that is one of the sort of most contentious issues at the heart of all of these sort of ongoing lawsuits right now.
Joseph, on a simple basis, does their paycheck shift when they're deployed federally?
Yes, it does. So if you are yourself a member of the National Guard, you would generally prefer to be under federal orders because the pay and benefits are better than they typically are when you're on state duty. But they're actually, it's interesting. So this question of federalization is binary. The Guard is either federalized or it isn't. This is something that the Supreme Court made very clear in a 1990 decision called Perpetuity Department of Defense, that members of the Guard wear three hats on their, they have three hats in their closet. They have their civilian hat, which is what they're wearing most of the time. They have their state militia hat, and then they have their federal army hat. And they can only wear one of those at any given time. But while the question of federalization is binary, the National Guard actually can operate in one of three different duty statuses. So the first is state active duty status, where they're under state command and control, they're carrying out a state mission governed by state law, state funding, state benefits, everything is state. On the opposite end of the spectrum, you have federalization, which can also be called Title 10 status, where they're under federal command and control, carrying out a federal mission up to and including going overseas to fight in a war. Federal pay and benefits, governed by federal law, everything is federal. A federalized National Guardsman is, for all intents and purposes, part of the active duty armed forces until they are returned to state status. In the middle, you have something called Title 32 status, where the Guard remains under state command and control, but they receive federal pay and benefits, and they can be used for certain federal missions at the request of the President or Secretary of Defense, but they haven't been federalized. Now that's really important, and federalization is really important because of the Pasquim-Tanis Act. The Pasquim-Tanis Act bars the federal armed forces from participating in civilian law enforcement unless doing so has been expressly authorized by Congress. Now, the key word there is federal armed forces. The Pasquim-Tanis Act does not apply to the National Guard when it is under state command and control. As a matter of federal law, the governor of Massachusetts is free to use the National Guard for law enforcement whenever the governor wants. Now, Massachusetts law may put restrictions on that, but federal law does not. When the National Guard is federalized, they become a part of the federal armed forces for the purpose of the Pasquim-Thomas Act and are subject to it unless some exception applies. So, returning briefly to those duty statuses, when the National Guard is federalized, they're subject to the Pasquim-Thomas Act. But when they're on state active duty status or Title 32 status, because they're under state command and control, they have not been federalized and are not subject to the Pasquim-Thomas Act.
So interestingly, in terms of the National Guard, it seems historically that there have been questions about its deployment, both when it's international as part of the Army or Air Force, and then domestically, as you just illustrated. I mean, going back to the use in wartime, um, the National Guard comprised the majority, or militia at least back then, okay, comprised the majority of the troops, right, in the Mexican-American War, the Civil War, the Spanish-American War. 18 divisions of the Guard were used in World War II. 140,000 guardsmen in the Korean War, 63,000 in Operation Desert Storm. And after 9/11, those deployments, getting to the nub of some of the sort of pinch issues, increased from 1 to 2 years maximum. A big strain when you talked about those three hats and the civilian time, the expectation that guardsmen had for, sort of doing this as a part-time thing, it became, really onerous during these war times. Give us a sense of that. So that's going to be part one of that interesting question, the international side of going to war as a National Guards person.
Yeah, the identity of the National Guard has changed pretty dramatically over, I would say, roughly the past 30 years. So historically, the function of the National Guard has been, it is primarily a sort of an entity that is concerned first and foremost with local matters. So if we go back to the colonial era, or even for much of the 19th century, it's the United States is a fairly agrarian country where police, as we understand them, don't really exist. There's maybe the sheriff or the U.S. Marshal, and that's pretty much it. Um, so part of the militia's function at that time was if there were some sort of group of people breaking the law that were, had overwhelmed the sheriff, were more than the sheriff could handle, or were more than, the U.S. Marshals could handle. In, say, 1840, it's pretty easy to overwhelm civilian authorities. There just weren't that many of them. So part of the militia's function at that time was to be sort of called out to, suppress lawbreakers. And it happened more frequently at that time. The militia's sort of military role was more secondary. And the militia, and for a large part of its existence, the National Guard, were sort of not seen as first-rate soldiers. I this may be apocryphal, but I've heard a quote attributed to George Washington that the Continental Army would have actually been better off if they were alone and the state militias had all gone home. Um, during the Revolutionary War, and even as recently as Desert Storm, the top military brass intentionally chose to keep National Guard units who were deployed to the Middle East far away from actual combat. Um, during Desert Storm, there was only one National Guard unit that actually, fired any shots in anger, and that was an artillery unit that, participated in part of the bombardment. But otherwise, National Guard units were sort of intentionally kept away from the front lines because the brass, the regular Army brass, thought of them as second-class soldiers. That is not the case. In a process that started with the end of the draft and really started to bear fruit in the sort of late 90s, early 2000s, the National Guard has changed into what is really a professional army in most senses. Um, the Pentagon adopted this policy that's called the total force idea, where the Pentagon treats the sort of active duty and reserve components at its disposal as one pool of troops. And so when the Pentagon is deciding, okay, how many armored divisions do we want? How many, infantry brigades do we want? They treat the National Guard and the active duty armed forces as one pool of troops when they're making those distributions. And today's National Guard, they really are trained and equipped to the same standard as the active duty armed forces, even though they aren't necessarily spending 100% of their time ready to be deployed anywhere at a given notice. But there are armored brigade combat teams in the National Guard. There are a lot of frontline combat units in the National Guard, and 40% of the troops that we sent to Afghanistan and Iraq were either National Guard or reservists. So, a significant fraction of National Guard personnel have combat experience, maybe even in many cases multiple tours in either Iraq or Afghanistan. So there's increasingly little distinction in practice between a National Guardsman and an active duty member of the Army, which is important when we're talking about domestic deployment of the military, because in 2025, both that active duty Army soldier and the National Guardsman, probably both of them have little or no training in responding to civil unrest or, engaging in law enforcement. Instead, both are oriented towards their role as soldiers.
As we dig in, Joseph, to that current use, okay, and for civil unrest or the allegation of civil unrest, um, it seems to me that here again we have a strange, not even mythology, but fact about the domestic deployment of the Guard, right? It had a history, after the Great Railroad Strike of 1877, it was deployed multiple times against the Union type work, right? The Homestead Strike, the Pullman Strike of 1894, Colorado labor laws. You move forward to the well-known, Little Rock High School in 1957. Governor Orville Faubus had used some Guard members to prevent young black students from entering the school. Eisenhower turned around and deployed the Guard to force the opening of the school, right? And so, but there is this torture. And then, of course, those of us that were, around then remember that on the one hand, during the Vietnam War, uh, going into the Guard, as you said, before it really became part of the total force, as a way to almost certainly avoid combat. And then on the other hand, in 1970, famously at Kent State, the Guard was called in and 4 students were shot. So this history, on a federal side, seems to me to have, am I right, some negativity, whereas on that state side, again, all sorts of local emergencies or whatever. Is that correct? Is there a tension that has been there about the Guard's work when under, as you said, there were two possible hats of that federalization and the Guard performing duties domestically?
I think you're hitting on something really important, which is we should look differently at a state deployment of the National Guard than a federal deployment of the National Guard or a federal deployment of the active duty armed forces. Um, you know, there is a tradition in this country of, local control of the militia, and generally of sort of local governments. Part of the story of America is partly one of sort of we should have local control over local matters. Um, but there's also a long tradition in this country of resistance towards both a sort of strong national executive and certainly of federal domestic use of the armed forces. The founding generation were deeply suspicious of military power, based partly on their study of history, but also partly on their own lived experience. For the people who were putting together the Constitution, their own, defining experience with what domestic deployment of the military was the Boston Massacre and the quartering of troops in private homes. There were vigorous debates at the Constitutional Convention about whether to even allow for the creation of a national standing army or to instead rely exclusively on the state militias. Now, at the same time, the founders knew what an emergency was. The Constitutional Convention was held just a year after Shays' Rebellion, which cast an enormous shadow over the proceedings there. Shays' Rebellion made abundantly clear that the government under the Articles of Confederation was too weak and was insufficiently able to defend itself. So the founders sought to strike a balance. So certainly they preserved, I would say a broader authority for state governor, state and local authorities to use their militia as they saw fit in its, traditional role of backing up civilian law enforcement in a crisis. Though again, even that, it's such a different world because, police as you and I understand them simply didn't exist. Most communities relied on a volunteer night watch model. There were no cops. But the authority of the federal government to use military force, whether it was militia or active duty, domestically was very, very limited. Well, actually, I say limited in terms of using active duty. There's a decent argument that the Constitution doesn't actually allow the use of the active duty armed forces domestically at all. Now, that's been permitted by statute since 1807 and has never been seriously challenged. But it's actually an interesting question of, whether the drafters of the Constitution contemplated ever allowing federal regulars to act domestically. With respect to, the president's use of the armed forces domestically, the tradition in this country has always been that the president deploying the militia or the active duty armed forces domestically to suppress unrest or execute the law is a last resort, to be used only when civilian authorities are genuinely overwhelmed by some sudden crisis, not having a hard time, not faced even with, a stiff challenge, but overwhelmed. And that doesn't happen very often. If you want to look for an example, the most recent, the last time the Insurrection Act was invoked, was the Los Angeles riots in 1992, where more than 60 people died, and large swaths of Los Angeles were in sort of a state of chaos for multiple days. But even there, that wasn't the president acting unilaterally. The governor of California requested federal military intervention under the Insurrection Act. To find an instance when, prior to June of this year, where a president has unilaterally deployed military forces to sort of execute the law or respond to civil unrest without a request from state governor, you have to go back to 1965. And between 1957 and 1965, there's a series of unilateral invocations of the Insurrection Act. And deployment of troops to execute the law, responding to civil unrest, or to enforce federal court orders, desegregating Southern schools. There's a 5 of them in a period of 7 years. Little Rock, Arkansas, the Ole Miss riot in 1962, and then 2 invocations of the Insurrection Act in Alabama in a basically 4-month span in 1963, and then a third and final one in Alabama in 1965. But I think it's really significant that all of those were in a context of civil rights enforcement. To find a situation where the president has acted unilaterally, deploying the armed forces to respond to execute the law without the request of the governor in a context other than civil rights enforcement, you have to go all the way back to 1894. It's been 130 years, and that was the Pullman strike in Chicago. And the Pullman strike is itself kind of an outlier. You won't find, even prior to that, a lot of situations where the president is deploying the military domestically, without the consent of a governor, uh, for that sort of purpose, where there's no civil rights issue and there's no like kind of actual rebellion. Incidents like the Whiskey Rebellion up to the Civil War sort of belong in their own category.
So Joseph, in what you're saying, the founding fathers, okay, and a suspicion and perhaps a question of legality ever for the deployment of the military, federal military, inside the United States. So from that, okay, let's say I would derive, well, then if we have a strict constructionist court, which we seem to, have now, at least some key members, and then we also have a very deferential Supreme Court to executive power, perhaps any court we've seen in quite a long time. So those two things in opposition, can you, from a legal perspective, can you give us a sense of expectation for how this court will handle the challenges to this, presidentially orchestrated use in situations where state governors are saying, "I don't have an emergency"?
It's hard to say. I think the court has sent some signals. Um, they've requested supplemental briefing on a sort of a kind of arcane question of statutory interpretation. That being, what is the meaning of the regular forces within paragraph 3 of this statute that's at issue, 10 U.S.C. section 12406. That to me suggests that
Hmm.
they intend to dig into this. I think we are likely to see um, some more rigorous review here. This, as you said, certain members of this court are, very much guided by sort of historical practice in this country, guided by kind of a stricter interpretation of the Constitution. And that, applied in good faith, I think that will lead them to be extraordinarily suspicious of these deployments. Um, what we are seeing here with the way this administration is using the military domestically has no real precedent in modern American history. Between these deployments to Los Angeles, Portland, and Chicago, additional deployments to Memphis and Washington, D.C., sending military personnel to the U.S.-Mexico border, establishing these so-called national defense areas there, using Air Force aircraft for deportation flights, detailing National Guard personnel to ICE facilities to assist with logistical tasks. In that and in many other ways, this administration is inserting the military into what is fundamentally routine law enforcement in a way that we've never seen before in this country. And this is not the military's job. The United States military is and always has been a fundamentally outward-faced entity that is, focused on defending the country against foreign threats rather than policing American citizens. There is no crisis in any of these cities that would justify these deployments, and certainly not that would justify them happening over the objections of these state governors. I would draw particular attention to the presidential memorandum issued on June 7th at the start of the deployment to Los Angeles, which does not mention Los Angeles, doesn't even mention California. It has no geographic or temporal bounds at all. It simply says wherever in the country ICE or federal law enforcement are being obstructed, the president is, claiming the authority to deploy military forces to, assist ICE with that law enforcement. No president in the history of this country has issued a memorandum like that. Even President Lincoln's invocation of the Insurrection Act at the outbreak of the Civil War, because the Insurrection Act was part of the legal authority for prosecuting the Civil War was confined to the states in rebellion. The last person to assert this kind of sweeping authority to use the military for law enforcement anywhere at any time for any reason in this country was King George. We've never seen anything like this before. And it is deeply un-American. This is not how we do things in the United States. This is not the relationship that the American people have with the United States Armed Forces. And it's not what that relationship has ever been.
Given what you just said, let's, as beginning our dismount here on an incredible conversation, the darkest scenario that is very, very prevalent, which is the martial law come election time scenario. Can you give us a sense there of both that real possibility and what perhaps before from the court, or what might intervene to prevent such a scenario?
I don't see martial law as a possibility that we're looking at right now. Martial law that term has no established definition in US law. It's normally understood to refer to this kind of emergency power that allows the military to sort of push aside civilian government and take its place and exercise jurisdiction directly over civilians. This is very different from, say, invoking the Insurrection Act, where the military is, participating in law enforcement, but is doing so at the direction of and in support of civilian authorities. They're not taking the place of civilian authorities. Martial law has been declared before in the history of this country. Around 90 or so times mostly between the start of the Civil War and the end of World War II. I'm sorry, around 60 or so times within that 90-year period. But the vast majority of those declarations of martial law were by states. Only 6 of them were by the federal government. The Supreme Court has never recognized a federal power to declare martial law. If there was such a power, it would absolutely have to be expressly authorized by Congress. No statute currently authorizes the declaration of martial law. And fundamentally, applying any kind of modern understanding of the Constitution, the notion of the military pushing aside civilian authorities and taking their place is simply not reconcilable with the basic tenets of our constitutional system. It could not be constitutional. That turns our entire constitutional system on its head. If you look to the Declaration of Independence, one of our principal charges against the British, against King George, was placing the military authority, independent of and superior to the civil power. Our country was, in a sense, founded on the rejection of something like martial law. So at this point in time, I don't see that as being a possibility. I worry about the continued sort of misuse of the president's statutory authorities to use the military domestically. Both, 10 U.S.C. Section 1246, potentially the Insurrection Act, other sort of other authorities as well. But I don't currently see us on a path towards what could be called martial law, as vague as that concept is.
And Joseph, just stepping back of that finally to, hearing you well, just the possibility that the guard is deployed in some way that could be construed as keeping people away from voting, that the conditions in an area, perhaps an area where ICE is simultaneously operating, and there's voters that perhaps are in that area, and now the guard is present. I mean, are there scenarios that are foreseeable in which you still have some kind of voter suppression?
I think It's a very it's a challenging question to answer because it's hard to predict the future. Um, I think what I would emphasize is that there are a variety of laws that explicitly prohibit any kind of military interference in elections, or above and beyond sort of the general prohibitions on intimidation of voters, interfering in elections. There are specific ones that specifically target the military. Um, you know, Placing federal troops or armed men at a polling location is a felony. Um, and someone might make the point that, well, is this Department of Justice likely to prosecute that sort of felony? Maybe it is, maybe it isn't. On the other hand, if you're a person who is asked to do that, your calculation might be different because maybe some person in the future might be prosecuting that felony. And I think that the laws here against any kind of military interference in an election are quite robust. Um, and um, I think what I would say is sorry, it's a question of how to phrase this exactly. Um, I think the law is very clear, that, any kind of military, the sort of prohibiting any kind of and punishing any kind of military interference in an election. And we can consider those federal laws, and we can also consider state laws that are devoted towards election security, uh, punishing any kind of interference in elections. I think the state of the law right now is very robust. The laws are very clear, and it's also very clear that those laws apply even if, say, the president has invoked the Insurrection Act. So, um, I think I would encourage anyone to vote, no matter the circumstances. And that's not something I'm currently worried about.
Well, you've given me a lot more optimism, and I think you've armed us to prevent some of the scariest scenarios that are simply afoot these days when we are seeing uses of the guard that are at least in modern times unprecedented. And so thank you, Joseph Nunn. It's been an extraordinary pleasure, and I do believe that you've helped a lot of us understand what can happen and what is not likely to happen at a time that is troubling for many people.
Well, thank you so much for having me, Dalton. I had a great time.
Viewers, uh, you can see the power of this kind of discussion. And if you're already a subscriber to the Berkshire Eagle, thank you. If you're not yet a subscriber, please consider becoming one. It's how we keep the flame of local journalism alive in this country. I'm Dalton Delan. I'll see you next time on Eagle Reels and in the pages of the Berkshire Eagle.